know if he's got his.
Hello and welcome to today's Top Patent Law Stories of 2019 webinar. My name is David and I will be in the background answering any WebEx technical questions. If you experience technical difficulty anytime during this WebEx event, please submit your technical issues in the Q&A panel at the right of the screen and I will assist you. Please note that as an attendee, you're part of a larger audience today. However, due to privacy concerns, the attendee list is not displayed. All attendees will be in a listen-only mode for the duration of today's call, and as a reminder, this call is being recorded. With that, we invite you to sit back, relax, and enjoy today's presentation. Now I'd like to introduce your first speaker for today, Don Zun. Don, you now have the floor.
Thank you. So welcome again to another installment of MBHB's Top Patent Law Stories. This time we're going to talk about stories from 2019. I'm Don Zun. I'm here with my partners Kevin Noonan and Mike Barella. Also, Patent Docs authors. And so for the past 13 years, we've been on the Patent Docs weblog putting together a list of the top patent stories for the previous year. And this year we had 15. I'm going to go through them as usual. We've got some Supreme Court decisions, some Federal Circuit decisions. We've got some actions by the Patent Office. We have some stuff involving the PTAB. We have Congress involved. So we have a lot of stuff on here. This year there were 15 stories. And down at the bottom of the previous slide, there's a link so you can go to the blog if you want to take a look at summaries for the 15 stories. Obviously, in 75 minutes, we do not have enough time to cover all 15 topics, so we've picked out a few that are on the slide that you see before you. And so without further ado, actually I need to do one bit of housekeeping first. So for today's seminar, please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note there are 2 randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will attempt to address submitted questions at the end of the webinar. If time does not permit, we will respond offline after the webinar. And I will tell you right now, I doubt we're going to have a lot of time at the end, but what we've done in years past is collect the questions that are submitted, so please submit questions, and then we put them on the blog, and we've had a chance to answer them and maybe have a little bit better dialogue with folks who want to discuss the topics a little bit further. And so now, without further ado, let me turn it over to Mike Barella, who's going to talk about some Supreme Court decisions.
All right, thanks, Don. So we have 3 Supreme Court decisions in 2019, and we're just going to get rolling on those. The first one is Helsin versus Teva, and this has to do with whether the AIA changed the interpretation of the on-sale bar. So before the AIA, Section 102, with respect to the on-sale bar, read that an invention is barred from patenting if it was on sale in this country more than 1 year prior to the date of application for patent. And the interpretation of this had traditionally been, through the case law, that patenting is barred when the invention is sold or offered for sale, even if the sale does not disclose the invention. And the reasoning for that is that you don't want someone commercially exploiting an invention without patenting it for some number of years, let's say, and then later going and filing a patent and getting another 20 years of exclusivity with it. So the language of the AIA is that an invention is barred from patenting if it was on sale or otherwise available to the public before the effective filing date. So the question is, does that change in the language, that addition of the phrase or otherwise available to the public, require a public disclosure of the actual invention? So here's our fact pattern. In April of 2001, Helsin made a deal with MGI Pharma to distribute and sell dosages of a drug. The contract was publicly, or the existence of the contract was publicly known. It was in financial filings from the companies, but the information regarding the formulation and dosage levels were not disclosed. So the invention was still a secret, but the existence of the sale was not. Over 1 year later, in January 2003, Helsin filed a provisional patent application directed towards what was in the contract but not disclosed, and then filed a string of non-provisionals. Most interestingly, one that evolved into the 219 patent, which in fact was filed after the AIA came into effect. So in 2001, Teva filed an ANDA. Helsin responded with a Hatch-Waxman suit. This gets taken care of in district court, and here we're going to focus on the 219 patent because that's the one that's most relevant to the discussion at hand. And the district court decided that the AIA indeed did change the meaning of the on-sale bar, and now Section 102 does require that a sale publicly disclose the details of the invention in order for the bar to be triggered. And since this didn't happen in the MGI agreement, Helsin was in good shape. Of course, this gets appealed to the Federal Circuit, and Helsin argued that the phrase otherwise available to the public did in fact change the law. The on-sale bar requires that a sale make the invention available to the public. And Helsin supported this argument with the fact that the statutory language was changed, and also with floor statements made by members of Congress to that effect. But the Federal Circuit disagreed. It said that there's a long-standing line of cases, essentially a common law notion, that it's clear that an invention is made available to the public when there is a commercial sale or offer for sale, even if the details of the invention are not disclosed, and that the floor statements and the statute, for that matter, contain no indication that Congress intended to overrule this long-standing principle. Right, that goes up to the Supreme Court, and essentially the Supreme Court agrees with the Federal Circuit. Congress, according to the court, Congress did not change the interpretation of the on-sale bar because there's insufficient evidence of that intent, and there's other ways to interpret the phrase otherwise available to the public, but the court left it open that a commercial sale to a third party who is required to keep the invention confidential may in fact place that invention on sale under the AIA. So what we're seeing here is the first instance of a theme amongst these three Supreme Court cases that came down last year. There's a long-standing common law principle, something that was developed in case law, and someone comes along and says, well, there's a statute that should be interpreted as overruling that case law. And as we see here, the court said that no, unless it's absolutely crystal clear that Congress wanted the statute to do that, it's not going to. So we'll move on to our second case, which is about post-grant reviews. And as we all know, there's three types of AIA reviews, inter-party, post-grant reviews, and CBMs, covered business method reviews. And statutorily, these are all available to a person who wishes to get rid of a patent. Now, Return Mail owned a patent which claims a method for processing undeliverable mail. It tried to get the U.S. Postal Service, which is obviously a branch of the federal government, to buy a license to that patent, essentially. The Postal Service ultimately declined and instead introduced their own method for taking care of undeliverable mail. Return Mail felt that its patent was being infringed, so it sues the Postal Office for infringement. The Postal Service then petitions for CBM review. The PTAB grants the petition, and ultimately in the PTAB, all the claims get canceled. This gets appealed up to the Federal Circuit, and the Federal Circuit affirms, indicating that it believes that the federal government is a person who can file for petition under the AIA. So, of course, we go to the Supreme Court here, and we had a decision come down on in June of last year. And here the court says, look, the statute itself doesn't clearly define what a person is, but the traditional fallback position, and here's our longstanding common law once again, is that there's a presumption that a person does not include the sovereign. So in other words, a person does not include the government. And they also looked at the Dictionary Act of 1947 that defines a person to include a number of entities, none of which are the government. Now, the Postal Service made some pretty good arguments in that this presumption should be or the facts here overcome that presumption. It says that the text of the AIA does, in fact, use the term person to refer to the government, and that federal agencies can participate in the patent system, and so therefore, why can't the Postal Service in this case participate in AIA reviews in front of the PTAB? But none of these points really, won the day for the Postal Service. The majority, which was 6 of the justices, found that the AIA is ambiguous in how it refers to the word person. Sometimes it might include the government and other times not, and that can't overcome a longstanding presumption or this longstanding common law. And there's also a degree of asymmetry in the way that the patent law treats the government. It doesn't treat the government like other entities. So not treating the government like other entities here is essentially in line with the statute as a whole. So the Postal Service loses, and in fact, the government cannot petition for AIA reviews. There was a dissent by Justice Breyer, and he was joined by Justices Ginsburg and Kagan, and he took a textual analysis, and he disagreed with the majority in that he found that the use of the word person in the statute was more clear than the majority thought, essentially. So he would have ruled in favor of finding that the government was a person, and then he also looked to the legislative purpose in his view of what why the AIA was passed, and he believes that the AIA was passed to get rid of so-called bad patents, and anything getting rid of bad patents was a good thing. So this tells you really more about Justice Breyer's position on things than perhaps anything else, but it's worthy to note that in the dissent that he was joined by 2 other justices in that regard. So let's move on to our last Supreme Court case, and this has to do with attorney's fees. So in Peer versus Nanquist, we all know that adverse PTAB decisions are usually appealed to the Federal Circuit, but there is another appeals path under Section 145 to the District Court for the Eastern District of Virginia. Now, this is not a particularly popular path. One of the reasons is that the statute itself states that all the expenses of the proceedings shall be paid by the applicant. So that means that if you drag the PTO into District Court, you have to pay, win or lose. The question here, though, is what does expenses mean? How broadly is that term going to be interpreted? So in this particular situation, Nanquist did file a complaint in the District Court for the Eastern District of Virginia after the PTO rejected all of its claims. Nanquist did lose in the District Court, appealed to the Federal Circuit, and lost again. So the case gets remanded back to the District Court for damages, and the PTO moved for an award of expenses, and that is not unusual because the statute says all the expenses shall be paid by the applicant. But in this particular case, for the first time ever, the PTO included pro rata salaries of attorneys and paralegals that worked on the case in those expenses. Well, the District Court didn't like that, and it denied the request. It goes back to the Federal Circuit. The Federal Circuit panel reverses the District Court and awards the fees, including attorney's fees, and then the en banc Federal Circuit reverses the panel. So coming out of the Federal Circuit, Nanquist is winning, and the USPTO is not getting attorney's fees. So the Supreme Court hears this case, and its decision comes down just a little bit more than a month ago. And at issue here is yet another one of these long-standing common law principles, and this is the American law, which essentially can be read as each litigant pays his own attorney's fees, win or lose, unless a statute or contract provides otherwise. Now, you would think if we flip back here to the actual text of the statute in the second bullet, all the expenses of the proceedings shall be paid by the applicant. That's in the statute. All right, so you would think that that would include attorney's fees. So the USPTO argued that the American rule didn't apply here because the statute requires the applicant to pay all expenses. It wasn't a prevailing party statute, and besides, all expenses means all expenses. Well, the court disagreed with this, and it said that this presumption against fee shifting is fairly fundamental. It applies to all statutes. We don't care whether it's a prevailing party statute or not, and that the text of 145 doesn't actually overcome the presumption of the American rule because traditionally the term expenses in litigation didn't include attorney's fees, and they look to other aspects or other statutes, and they find that the terms expenses and attorney's fees are often used together which suggests or indicates that expenses do not include attorney's fees. Furthermore, and this is probably another major factor of why the court went the way it did, is it said, look, Patent Office, you've never in 170 years asked for attorney's fees before. Why are you doing so now? Where is your financial need? And apparently the PTO didn't have a good answer for that. So ultimately, the PTO loses. They cannot recover attorney's fees when you take them into district court. All right, so we're going to move on to our next section, and I'm going to hand things back to Mr. Zune.
Thank you, Mike. So Mike's going to come back a little bit later and talk about some high-tech subject matter eligibility stuff, and technical term. And I point that out because what I'm going to talk about now is life sciences subject matter eligibility. So if you're a high-tech person, please don't ignore me. Please don't, go get a cup of coffee, listen, because I think that at least with respect to what's happening with some of the diagnostic method patents and how the Federal Circuit is handling that, and specifically I'm talking about Athena Diagnostics, there's something there I think that would be helpful for all practitioners and all applicants, regardless of the subject matter that you're pursuing in your applications. And then I'm going to talk about kind of a related issue involving method of treatment patents, and that also might provide a little bit of enlightenment for high-tech folks and maybe a pathway forward for dealing with this morass that's subject matter eligibility. So first I'm going to talk about the life sciences method of diagnostic claims. So as we all know, there's been a lot of district court, Federal Circuit, and Supreme Court decisions on high-tech patents involving subject matter eligibility, but life sciences hasn't been sold short on this either, and we've got a number of cases going all the way back to Mayo v. Prometheus in 2012. And if you look at the bottom of this timeline here, the cases that are in red, highlighted in red, that all happened in 2019. So there's been a lot of recent activity. And what we're seeing on the life sciences side is a dichotomy between diagnostic patents and treatment patents. And so in the last 2 years, the Federal Circuit has issued a number of decisions on diagnostic claims, and they have found all of those claims to be patent ineligible. And at the same time, the Federal Circuit has also issued a number of decisions on method of treatment claims, and they found all of those claims to be patent eligible. So we've got this dichotomy, and a little later I'm going to talk about an opinion, a comment Judge Moore made in an opinion where she finds this dichotomy difficult to resolve. I agree with her, and I find it difficult to resolve as well. So let's talk about Athena Diagnostics. So in this case, Athena asserts the 820 patent against Mayo, Mayo from Mayo Prometheus, and argue that Mayo has infringed the patent that's directed to a diagnostic method for MG, a chronic autoimmune disorder. And what Athena has determined is that typically you look at the acetylcholine receptor autoantibodies to determine folks who have MG, but 20% of these MG patents lack those autoantibodies, and instead what Athena found is that they have a different autoantibody to MuSK, muscle-specific tyrosine kinase. And so in this case, claims 6 to 9 are at issue, and they all depend directly or indirectly from claims 1 to 3. Here I put claims 1 to 3 up, not because they were involved in the case, but you can see we have a classic method of diagnosing claim here. And here are the claims that were asserted, and these depend from the first 3 claims. And what these claims are directed to is using a reporter molecule that's radioactively labeled to do the detection of these autoantibodies. So at the district court level, Mayo moved to dismiss Athena's complaint, arguing that the 820 patent was directed to patent ineligible subject matter, and the district court followed the classic Mayo-Alice two-step analysis for subject matter eligibility, and at step 1, they said this is a naturally occurring interaction, and at step 2, they said that the claim lacks inventive concept, because what you're doing here is just using well-known techniques to identify the presence of these MuSK autoantibodies. So the district court granted that motion to dismiss. So now we come to 2019 and what's happened in this case in 2019. So in February, a divided Federal Circuit panel affirms the district court decision that the claims are directed to patent ineligible subject matter for basically the same reason that the district court had found the claims to be patent ineligible. And the majority interestingly enough, distinguished this case from Vanda, which was one of the method of treatment claim patents that I mentioned earlier in this dichotomy. And here the majority said that in distinguishing the claims in Athena from the claims in Vanda, that claiming a new treatment for an ailment, albeit using a natural law, is not claiming the natural law. So the majority, reflecting on Judge Newman's dissent, figures it would be Judge Newman writing a dissent, said that there was much in her opinion that they could agree with from a policy standpoint, but their hands are tied by the Supreme Court's decision in Mayo v. Prometheus. And so here, Judge Lurie says, our precedent leaves no room for a different outcome. So come to July, fast forward to July, and this seemed very fast to me, going from panel decision, then we've got an en banc order, especially given that the en banc order was almost 90 pages long, and the order itself was only 4 pages. But the reason it was so long was because in this order denying Athena's petition for rehearing, there were 8 different opinions, 4 concurring and 4 dissenting. For the concurring opinions, we have 7 members of the Federal Circuit concurring in the denial, and for the dissenting opinions, we have 5 members dissenting in the denial. So with respect to the concurrences, let's look at them because the concurrences and the dissents kind of clearly indicate the difficulty that the Federal Circuit is having with the issue of subject matter eligibility. And this, I think, is where all practitioners and applicants can garner some good information from this en banc order. So Judge Lurie writes one of the concurrences. First of all, I should say that all of the concurrences, the general theme is that they believe that their hands are tied by the Supreme Court's decision in Mayo v. Prometheus. And Judge Lurie kind of takes us back to a time before the judicial exceptions and says if he could write on a clean slate, he would not exclude uses or detections of natural laws, and that he thinks that the laws of anticipation, obviousness, indefiniteness, and written description could provide other filters for this. And as far as a solution to the problem, Judge Lurie points to the pens of claim drafters or legislators. Well, Mike is going to talk a little bit later about the legislation part, and I'm going to talk in a few minutes about the pens of claim drafters part. So I think Judge Lurie is on the right track, or at least halfway on the right track. And his point is that the Federal Circuit is neither Congress nor claim drafters. Judge Hughes, who writes another concurrence, he looks to the Supreme Court for guidance or alternatively Congress. And again, Mike's going to talk about Congress in a few minutes. Judge Dyke, he thinks that that if a claim is sufficiently tied to a specific and useful application of a natural law at Mayo Step 1, that itself should serve as the inventive concept to get past Mayo Step 2, but acknowledges that's not the way it is. And so, he also believes that he's kind of tied to Mayo, even though he thinks Mayo may be overbroad. Judge Chen, who writes the 4th concurrence, he also looks to the Supreme Court for guidance. Moving over to the dissents, we have several dissenting authors disagreeing with the concurring authors that Mayo compels, the Mayo Prometheus compels a finding of patent eligibility in the Athena case. And Judge Moore, as I mentioned earlier, she has a problem with this dichotomy. She believes that that a claim that covers a specific concrete application of a natural law should be, regardless of whether it's a diagnostic method or a therapeutic method, both should be patent eligible. And again, I agree with her, but that isn't where we are, and it doesn't look like that's where we're ever going to get, at least until and if Congress steps in. So also Judge Moore believes that even if stuck with Mayo, that Mayo doesn't compel a decision that all diagnostic claims should be found to be patent ineligible. And as I mentioned earlier, that is the case before the Federal Circuit. All of the cases involving diagnostic claims are found to be patent ineligible. Judge Newman, who wrote the dissent in the panel decision, kind of agrees that the court has mistakenly enlarged the Supreme Court's holding in Mayo v. Prometheus. Judge Stoll kind of blames both the Supreme Court and the Federal Circuit. So she blames the Supreme Court for an overreaching and flawed test for eligibility, but maybe takes places more blame on the Federal Circuit for, in her words, consistently bypassing en banc review of this critical issue and saying that the Federal Circuit is abdicating its responsibility in this area. Judge O'Malley, who writes the final dissenting opinion, was very direct, and so for her, the problem is the Supreme Court, which she says has ignored Congress's direction to the courts to apply Section 101 and other sections in the Patent Act as written. And she says that the Supreme Court has instructed federal courts to read into Section 101 an inventive concept requirement that she calls a baffling standard that Congress removed when it amended the Patent Act in 1952. I would say that when you have an order that it has 88 pages of 8 opinions with a 7-5 split on the Federal Circuit, that Judge O'Malley's onto something here where she says that this standard is baffling, because it clearly is baffling the Federal Circuit. And Judge O'Malley encourages Congress to amend the Patent Act once more to clarify that it meant what it said in 1952, so very direct. And again, as I mentioned, Mike's going to talk about what Congress is doing. But let's move on and deal with what we have here with Athena. So Athena Diagnostics filed a petition for cert. Here's the question presented. You can look at that on your own time because it doesn't really matter, because the Supreme Court last week on Monday denied that petition for cert. And so we're stuck with Athena. So again, all of the judges in the order who said or kind of implored the Supreme Court to provide more guidance, well, the Supreme Court isn't going to do that. And they're not going to provide more guidance. They, for whatever reason, don't think they need to provide guidance, but you're not going to get that guidance. And so we have to look at some of the other suggestions. As I mentioned, Judge Lurie said pens of the claim drafters. And so let's talk about that. And I think here we have this dichotomy, and I think the judges who asked for the Federal Circuit to deal with Mayo as it's been handed to them, they're kind of right, because with this dichotomy, the Federal Circuit has been doing a lot of good things if you want to get these claims allowed, issued on the method of treatment side. And now it's up to us, claims drafters, to take this hint, the suggestion, and work with it. So in Vanda, which was a top story case last year, we have a method of treating schizophrenia using iloperidone. And in that case, the district court found that the claims were not patent ineligible, or so were patent eligible, and a divided Federal Circuit panel affirmed that finding. And so this is the reason why it made our top stories list last year, a big case. So here's the claim, classic method of treating, and what we have is kind of a diagnostic component up there in the determining step, where you're looking to see whether the patient is a CYP 2D6 poor metabolizer, has that genotype, and if they do, then you give them 12 milligrams per day or less of this drug. And if they're not, and they don't have this genotype, you give them up to 24 milligrams per day. And so it has a strong diagnostic component. And I don't think this is a bad result, because if you are looking for a diagnostic, you're theoretically looking to do something with it. You're not just diagnosing patients and not trying to figure out how to help them. So I think you can convert a lot of claims, maybe not all claims, that are diagnostic claims and method of treatment. I've done this recently. We just got a patent allowed that we were prosecuting for 8 years, which was a classic diagnostic case, and converted it into a method of treatment claim and finally got it allowed. So in the Vanda case, why is Vanda here besides the fact that it, counters the discussion on Athena? Well, there is some stuff that happened in 2019 with Vanda, but just tying up the rest of the Vanda decision from the Federal Circuit in 2018, Westward had argued that the claims were invalid, they were indistinguishable from the claims that were involved in Mayo v. Prometheus, and the Federal Circuit at the time said this case is not Mayo. The claims in Mayo were directed to a novel method of treating a disease. So set aside for the moment, like what Judge Moore said, that it doesn't make sense maybe to her and others that a diagnostic method would be a patent-ineligible application and a method of treatment would be a patent-eligible application, but that's where we are right now. And we have two cases that came down in 2019 where the Federal Circuit did basically the same thing. So we have Natural Alternatives v. Creative Compounds, and here we have a method of regulating hydronium ion concentrations and a method of increasing anaerobic working capacity. So not classic method of treatment claims, but in that kind of same vein. Natural Alternatives asserted 6 patents against Creative Compounds. The district court found the claims to be patent ineligible, and a divided Federal Circuit panel reversed and remanded the district court, finding that the claims are not directed to ineligible subject matter under Alice Step 1. EndoPharm is another case that came down this year along the lines of Vanda, and this is a more classic method of treatment case. So we have a method of treating pain in a renally impaired patient, and we have a measurement step in Step B. So you're kind of figuring out what patient population is best suited for this treatment. And in that case, Endo filed suit against a number of generics, asserting the 737 patent, which again is directed to a method of using oxymorphone to treat pain in patients with impaired kidney function. Just like in Natural Alternatives, the district court found the claims to be patent ineligible, and the Federal Circuit, again, just like in Natural Alternatives, reversed the district court, concluding that the asserted claims are not directed to patent ineligible subject matter. So where does that leave us? Well, if you go back to the Vanda case, the Federal Circuit had a very informative paragraph in the opinion, at least I think it's informative, and what I've been calling it is the 5 specificities. And so in none of these cases does the Federal Circuit require that you satisfy all 5 of these specificities. But the way I've been treating them is the more of these 5 that you can satisfy, the more likely you are to get your claim allowed and kind of convert your diagnostic claim into a treatment claim. So what we have here is the Federal Circuit saying the claims here are directed to a specific method of treatment for specific patients using a specific compound at specific doses to achieve a specific outcome. Again, the more of these 5 things that you can get, probably the better that you are at getting your claims allowed. So again, why is Vanda here? Because some stuff happened in 2019 with respect to Vanda and more recently. So Hikma Pharmaceuticals, which was the successor to Westward Pharma, they filed a petition for cert in this case, and the Supreme Court asked the Solicitor General for input on the government's position with respect to Vanda, and the Solicitor General said Vanda is not an optimal vehicle for bringing greater clarity to the Section 101 issue because the Court of Appeals majority arrived at the correct result. And on the same day that the Supreme Court denied cert in Athena last week, they denied cert in Vanda. So what that tells us is that at least the Supreme Court didn't find any issues with how the Federal Circuit handled the Vanda case, and so this looks like a good avenue if you want to get your claims allowed. And so the take-home messages for life sciences practitioners are pretty obvious. If you've got a diagnostic claim, try to convert it to a method of treatment with a diagnostic component. And for folks who don't prosecute either of these types of claims, and you're on the high-tech side, what's the message there for you? And Mike maybe can chime in when he talks about subject matter eligibility. Maybe it's trying to find an analogous way of making lemonade out of your lemons, or something along that line. On the high-tech side, and also realizing that there is a mess at the Federal Circuit, not that we didn't know this already, with respect to subject matter eligibility, given the 8 opinions and the 7-5 split and all the different solutions, and there's no consensus in the Federal Circuit where the solutions come from. And so I think with respect to this, the solution comes from the Federal Circuit treating these two differently, these two types of claims differently, even though Judge Moore doesn't like it, and I agree with her, and the claims, the pens of the claims drafters in converting the claims. And with that, we are going to take a pause for a minute, and I see we're on schedule, so that's good. So we're going to pause for a minute and allow you to put in this poll tracking word stories into the WebEx poll if you want to get CLE credit. And then after we leave this up for a little bit so everybody gets their CLE credit, we do not want to deny CLE credit to anyone. So, and while we're waiting for you to fill in this, I will say that we've seen a lot of questions for the parts that we discussed. If we have time, we'll get to those, and if we don't, we will definitely address your questions. And if we have a lot of good questions, probably in a post on the blog.
So this is Kevin Noonan. I'm going to talk to you about sovereign immunity in a minute. I'm going to leave this up. But while this is up, I'll talk about what I'm not going to talk about. I'm not going to talk about tribal sovereign immunity. That was last year. It's relevant to what the Supreme Court did with state sovereign, or the Federal Circuit did with state sovereign immunity this year. But I just want you to remember that the decision was that the tribes could not invoke sovereign immunity to get themselves out of IPRs in front of the PTAB. So this is just, now state sovereign immunity is a kind of a different animal, and the reason it is this is now the 11th Amendment. I'm not going to belabor that, but states have always had, because of the nature of how states came into the federal union, have always had this sovereignty that is respected in the federal system with some exceptions, and the Supreme Court accordingly has interpreted that very broadly. Generally, in the patent context, states have immunity from infringement and invalidity and inventorship. In fact, it was a few years ago that California invoked sovereign immunity to allow it to infringe somebody's patent with impunity. When it comes to asserting sovereign immunity in their own patents, state universities qualify because they're an arm of the state generally. So Princeton, for example, would not, but Rutgers would. And typically what happens is the answer is, has the state waived this immunity, and mere participation in the patent system doesn't constitute waiver. Also, a state can't be sued by a citizen in a federal agency. This is this Federal Maritime Commission versus South Carolina State Ports Authority case, which, if you remember from the tribal sovereign immunity, was used by both parties to support their positions. Basically, South Carolina was immune from an administrative proceeding brought by a citizen. It was a 5-4 vote, though. The reason in this case was the overwhelming similarities between the proceedings in civil litigation. Now, the board has ruled that FMC. We're going to go back one, Mike. Thank you. The board has ruled that FMC applied to make states immune from IPRs, and they have the COVID and neocord reactive surfaces cases. These were all on institution. And so this was never reviewed by the Federal Circuit because Congress said the Federal Circuit couldn't review institution decisions. But in going back to the states, these are 3 cases or 4 cases where the states, the courts have recognized that states have sovereign immunity. The Florida prepaid case was the granddaddy case back from the 1990s by the Supreme Court. But there have been a few further cases about this Gensetic case is about an involuntary plaintiff when the state was dragged in because it was the patent owner. The ZChem case was whether it was waiver, and the court said there has to be specific conduct in order to have waiver. But the thing to keep in mind is that state sovereign immunity has not been ruled to be plenary and can be waived. So this Board of Regents case had to do with venue. And the court said that states were just as subject to the venue rules as anybody else in patent litigation. The importance of this case is that the argument the state made is, and it's an argument we'll see again, is that the states have the right to determine what fora, where are they going to be sued, and that's the whole point of the 11th Amendment. But the court said no, venue applies. The University of Florida case was a waiver case, and the University of Utah case is a very interesting case because the University of Colorado was involved as well. And this was a case where the party said, or the University of Utah said, this is a dispute between 2 states. Granted, 2 state universities, but they were arms of the states. Those 2 states. Guess what? That's the Supreme Court's original jurisdiction, is to mediate disputes between states. So their argument was, you don't have jurisdiction to hear this case. We should be before the Supreme Court. And then the court said, no, that's not the way it's going to work. So in the case we're going to talk about in some depth, the Regents of University of Minnesota versus LSI, the Regents sued LSI on several patents and several other defendants, and each of the defendants, surprise, surprise, filed an IPR. Well, the Regents immediately moved to dismiss based on state sovereign immunity, and the PTAB denied the motion, basically saying you've waived this by bringing suit in district court, but still stayed to allow the Regents to appeal to the Federal Circuit. The position, of course, was state sovereign immunity, that the state had a right to determine where it was going to be sued, and they didn't agree to have this proceeding brought in front of the PTAB. And the Federal Circuit disagreed, interestingly applying a rationale that is very similar to the St. Regis Mohawk tribe, which, of course, remember, Indian tribal sovereign immunity is a very different animal from state sovereign immunity because, first of all, it can be abrogated by Congress. Congress can, in fact, Congress was preparing to, if you remember, if for some reason the courts had sided with St. Regis. I think the senator from Missouri had a bill all queued up and ready to go to abrogate Indian tribal sovereign immunity. Well, that's not an option here. But the panel, which is Judges Dyke, Wallach, and Hughes, said that, well, first of all, if you think about it, states have been getting patents for a long time, and states have never said that they were not subject to ex parte reexamination or inter partes reexaminations. So this is kind of the same animal as that. And you remember this was the argument that was made in the Indian tribal sovereign immunity cases. This is something that's not of the same flavor as those actions that have been granted sovereign immunity to states or Indian tribes. In fact, they say this is more an action by the government under the federal agency, the Patent Office, but really falls within that scope of an exception to the immunity under the Federal Maritime Commission case. Again, that case can be read both ways. And if you think about it, if you substitute the Patent Office for the EPA or OSHA or any other government agency, the argument makes a little bit more sense that you can't have a state, for example, polluting the waters or going against a federal worker safety just because they want to, just because of state sovereign immunity. And the same thing would apply here. But the court explicated more. Why are IPRs more like an agency action than private party litigation? And remember, one of the arguments in making the PTAB and in doing IPRs was to have this be more litigation-like. But the court says, no, if you think about it, the director is a political appointee, and the director is who institutes the IPR, not the private party. So this isn't a case where the PTAB even though this was how it was sold to Congress, this isn't a case where the PTAB is just acting like a judge as the parties dispute below. This is really something that, because the director's discretion on whether to institute in the first place is plenary and can't be challenged by judicial review, this is an agency action. Similarly, what happens if the third-party challenger drops out? Well, as we know, the PTAB can continue the IPR under those circumstances. And so that, again, is the flavor of agency action. And it really isn't the same as civil litigation, which it isn't. But interestingly, one of the things is that you can't have amended claims here. So in all the flavors and all the ways this looks, according to the court, this is really much more like an agency action, like an ex parte reexamination, inter parte reexamination, than it is as an adjudication. And then remember, in all oil states talked about private rights versus public rights, and oil states said a patent is a public right, and therefore it was proper to be resolved in an Article III forum. And if that's the case, then this is much more like the FMC case, where you could, in fact, have the government bringing something against the state, and state sovereign immunity wouldn't lie. There are also additional views. The court, all the judges wrote additional views, I think, to bolster their decision, and that was that, as we heard before in these sovereign immunity cases, this is a proceeding in rem. As to the patent, as to the thing, like any other property, so it's not in personam, and also the analogy was to bankruptcy proceedings to the same effect. So petition for certiorari, and like Don, I'm not going to belabor the question presented, which is here. The Supreme Court denied the petition. On the same day, they denied Athena, and they denied Vanda. And obviously, Don didn't talk about it, but they denied Berkheimer, and so...
they were very busy.
They were deciding not to be busy when it came to patent cases. And so the rule now is, the law is that patent proceedings are not subject to sovereign immunity by anybody. And if you get sued as an IPR and try to assert it, you're going to get shot down. So now I'm going to turn it back, I think, to Mike.
All right, thanks, Kevin. So we're going to move right along into subject matter eligibility, and we're going to address it from the point of view of the executive branch, the PTO, and then from the point of view of Congress. And as we've seen from the denials of cert that came down just last week, it looks like the Supreme Court has decided to do absolutely nothing with respect to 101. They're going to leave it as is for now for whatever reason they want to do that. So let's take a look at what the other branches of government are doing. So last year, the USPTO updated its subject matter eligibility guidance twice. Now, this guidance is it's not truly binding on examiners and the PTAB because it's guidance. It's not an actual rule, but it tells the examiners and the PTAB how to apply the 101 test. And the reason why the PTO did this is that it has been struggling with applying 101 in a consistent and reasonable fashion since Mayo and Alice. And that's because the precedent coming out of the Supreme Court and the Federal Circuit, as Don and Kevin have explained, it's quite unclear and, in fact, conflicting from time to time. So what this results in, and what we see in practice, is that we have different standards coming from being applied by different art units with respect to the 101 test, and even different examiners within the same art unit might be applying 101 differently from one another. And the other thing is that now since Alice, there's at least 130, maybe more cases. There's so many that we've lost count. Federal Circuit cases on Section 101. So this is too much case law for examiners who, for the most part, are not attorneys to be able to digest and apply. So in January, the USPTO made a significant update to its eligibility test, and they are now applying a test that is at least slightly different from what's being applied in the courts. They also added a number of example claims and analysis of these claims so that we can understand at least how the test can be applied in these hypothetical examples. And then in October, there was a relatively minor update that was probably more notable for what it didn't say than for what it did say. So what happened in the January guidance update is that they broke the Alice test, step one of the Alice test, which is, or I'll call it prong one of the Alice test. It's hard to keep this clear because it's actually step 2A of the USPTO's test. They broke that up into two parts. So let's just take a look at the flow chart on the right. Step one of the USPTO's Section 101 flowchart is looking at the statute, is the claim in one of the four statutory categories. That's actually a really easy decision to make. For the most part, the answer is yes. And then you go on to the two steps of Alice. And in the judicial branch, as they're applying the test now, The first step of ALICE, which is step 2A in the USPTO's flowchart, is you ask the question, is the claim directed to a judicial exception, such as an abstract idea, law of nature, natural phenomenon? And then step 2, or step 2B, prong 2 of ALICE, is whether the claim recites significantly more than that judicial exception. So the PTO has broken up step 2A, or prong 1 of ALICE, into two parts. The first part is, does the claim recite a judicial exception? So not is it directed to, but does it actually recite one? And then if it does, and part 2 is the question, is the judicial exception integrated into a practical application? All right, so, of course, this doesn't necessarily make things simpler. If anything, we're kind of reapplying the ALICE test in a recursive fashion in prong 1 of ALICE. But this doesn't change anything in step 2B. So the USPTO's guidance doesn't affect step 2B, which is still controlled by Alice Berkheimer and a number of other cases. The other thing that the PTO did in an attempt to make things simpler for examiners and arguably for patentees as well, is that they've taken the abstract idea exception, which is where the vast majority of these 101 disputes end up falling under, and they've bucketized it into 3 distinct categories or classes: mental processes, mathematical concepts, and certain methods of organizing human activity. And now when you look at these, you might think, well, that's good. I mean, at least it sort of limits what you need to look for with respect to the abstract idea exception, maybe even restricts how examiners can apply the abstract idea exception, so they're not going to be making up abstract ideas of their own. But in practice, these are very broad categories, so it hasn't really done much to restrain the scope of prong 1 of ALICE. So what are some observations from the ground with respect to how the USPTO has actually been applying this guidance over the last year? Most examiners are, in fact, taking the guidance quite seriously, and they're following it. And so we've seen a number of long-held 101 rejections being withdrawn because the examiners apply the guidance and they say, well, now, if I apply it the way the PTO wants me to apply it, I can't reject your claim anymore. So there was that happening in the first half of 2019, where we were getting a lot of 101 rejections being withdrawn when those rejections had been sitting around for 2, 3, 4 years or even more. There's also been numerous PTAB decisions where examiners have been reversed on 101 grounds, and some of these have been published as informative decisions. I believe there's 6 now that have been published. If you go to the URL listed here, you can see them. And we've written about all of them on the Patent Docs website, and they're definitely worth reading because it gives you a window into how the PTAB at least is thinking about how the guidance should be applied. Nonetheless, some of the example claims and the accompanying analyses are not exactly crystal clear. They're even counterintuitive because, at least in theory, if you read the guidance and you read the example claims the way that I have, you can narrow an eligible claim to make it ineligible, which seems a bit counterintuitive. The October update came out, and like I said, there wasn't much to report. It just clarified a few issues, but if you jump down to the bullet below, the final bullet on this slide, there's still issues with confusing examples, not a very clear description of what the examiner's prima facie case requirements are, as well as the October update, just like the January update, not addressing conclusory reasoning, which we see a lot in 101 rejections coming from examiners and in some cases from the PTAB. So the judicial branch is, the executive branch is doing its part to try to make up for the inactivity in the judicial branch with respect to 101, but what's going on in Congress? Well, there was a lot of noise in the spring and summer of last year, and in particular, Senators Tillis and Coons released a statement in June, essentially lambasting the Supreme Court and stating that effectively the court had bollocksed up Section 101, and now it's harming American innovation because very important new areas of research like medical diagnostics that we discussed and other things like AI and quantum computing are harder to obtain patents on than they should be because Section 101 is confusing and it's too narrow. So they proposed legislation, which I'm showing most of here. The most important part is the changes to Section 101 itself. And if you look at Part A, that's essentially what the statute says today, and then the proposed changes would be Part B, which states that eligibility should be determined by considering the invention as a whole without ignoring any part of it, which is helpful because that's exactly what happens both at the Patent Office and in the courts these days, is parts of claims get ignored when doing the eligibility analysis. Also, Section 100, which is the definition section, defines the term useful, which is used in Section 101, to mean any invention or discovery that provides specific practical utility in any field of technology. I'll talk about that in a bit. And some of the comments about how how these proposed laws would be applied indicate that Section 101 should be construed in favor of eligibility. And then also there's no judicially created exceptions that are going to be honored anymore, so it essentially overrules Alice and Mayo. And finally, the Congress or the committee that did this work indicated that there should be no overlap between Sections 101, 102, 103, and 112, which we all know is essentially a problem today. So there were hearings that were held over the summer, 7 hours. There were 45 witnesses total from academia, industry, and lobbying groups. I would say a majority of these witnesses testified that were pro-reform, and they cited that there were a lot of problems with the way the law was being applied, and there was a lack of patent protection in those emerging technological areas that we just discussed before. There was a vocal minority that were anti-reform, and effectively their position could be summarized as saying that Alice is good because it allows early dismissal of lawsuits with bad patents. So, we have a few bad patents out there, so let's use this nuclear bomb in the form of Alice to get rid of all of them. So some concerns remain, mostly with the definitions from Section 100 that were proposed. It's not really clear what specific and practical utility or any field of technology means, and there's some concern that unless this is clarified, the courts could essentially use this ambiguity in the language to backdoor a variation of the Alice test back into Section 101. All right, and so what happened after all this noise? Essentially nothing. Crickets so far from Congress since late summer. There have been a few individual senators that have been complaining about overreaching 101 decisions from the Federal Circuit, and there have been at least 3 of those that last year, which I wish we had time to talk about, but we don't. But nonetheless, it looks like right now, unless they're in stealth mode, that Congress is not going to do anything about 101. So we have the Supreme Court denying cert on 101 cases. We have Congress deciding to do nothing about Section 101. The Patent Office is struggling in applying 101 and coming up with its own rules, which are different from how the statute's being applied in court. And that's pretty much where we are with respect to patent eligibility in early 2020. All right, so we are going to pause again for another minute or so, allow you to enter in the word stories into the tracking poll so that you can get your CLE credit. And we'll give you a little bit of time to do that, and then we're going to move on to Kevin, and he's going to wrap things up with a discussion of post-grant review, and if there's time, the Doctrine of Equivalence.
And before Kevin starts playing, I just want to make a plug for Mike's next webinar. He's going to be doing one on February 18th, I think, which will be all about high-tech subject matter eligibility. And so if you went through things a little bit quickly, he'll have 75 minutes to devote to that topic.
Yeah, thanks, Don. And we are under very limited time to do all of the stories for 2019 in this particular webinar, but there is more than enough 101 stuff to talk about for a whole nother 75 minutes, if not much more. So tune in next month.
Okay. So unlikely to do both, but we'll give it a try. This is the Article 2, Section 2, Clause 2. I've been watching the news. President Trump had a hard time reciting this, according to a book that recently came out. But the importance here is that the president has the duty and the right to nominate and appoint all these people, including all the officers of the United States. But you can also have Congress vest appointment of inferior officers in either the president, the courts, or the heads of the departments. And so the question here is not really out of the blue, but I think many people were surprised by it. In a case that came out on Halloween, the Federal Circuit held, Judges Moore, Reyna, and Chen, that the PTAB APJs were principal officers and therefore had to be appointed by the President and confirmed by the Senate. In 2007, Professor John Duffy wrote a paper that essentially floated this idea, and 12 years later it came to fruition. The way it is now, the APJs are designated by the Secretary of Commerce and under control of the Director, and the Director, as you will remember, is responsible for all the post-grant proceedings but has delegated that authority to the APJs. The reason this is important is a separation of power issue. Basically, the idea here is that if the Senate has to confirm, it prevents the President from just delegating all of his responsibilities to non-elected officials. What the court is called the structural protection against diffusion of that accountability, and the pithy, the people don't vote for appointed officers. So why did the Federal Circuit come to this conclusion? Well, the APJs hold a continuing office established by law, created by statute. They exercise significant discretion when they carry out their reviews. They issue the final written decisions that have findings of fact and conclusions of law, and the decisions are final, subject to judicial review. There are three factors from the Edmund v. United States Court decision by the Supreme Court in 1997 of how to define an inferior officer. One is whether a principal officer that has gone through Senate confirmation has the power to review and reverse the officer's decision, what is the level of supervision and oversight that the appointed official has, and does the appointed official have the power to remove the officers from office. So applying this, only the Secretary of Commerce and the Director are the principal officers that provide direction to the PTO and its personnel, but neither of them satisfy the Edmunds test. And the court went through the three prongs fairly explicitly. The review power, neither the Secretary nor the Director has the authority to review a final written decision before the Patent Office has PTAB has issued it, so they don't get to put their thumb on the scale. The Director doesn't have the statutory authority to review, nullify, or reverse a final written decision, doesn't have the power to appeal a final written decision. All of these things, according to the court, were in favor of APJs being principal officers. In terms of the supervisory power, the Director has independent authority to institute, although that's delegated to the APJs in practice. The Director authorizes the panels of APJs who will hear and decide the IPRs, and in fact has included either himself or other APJs, expanded panels, and there was a kerfuffle a year and a half or so ago where the Director's power was again seen as influencing the decision, and of course the Director has the power to authorize pay and bonuses. So this prong was in favor of the APJs being inferior officers, but in terms of the removal power, there was no unfettered authority to remove an APJ, and it isn't even clear to the court whether the Director has the authority to remove an APJ from a particular panel, because the court said this would be inconsistent with the speedy adjudication provisions of the AIA. Although the Director can promulgate regulations, can't modify decisions or even correct misstatements of the law, and the APJs can only be removed for such causes will promote efficiency of the service, for misconduct likely to have an adverse impact on the agency's performance of its functions under 5 U.S.C. 7513, and these provisions favor the APJs as being principal officers. The other thing that the court noted is that examiners-in-chief back in the day, which were the predecessors to APJs, were principal officers subject to presidential appointment and Senate confirmation. So, and the court says there can be no reasonable dispute that APJs have a lot more authority than examiners-in-chief ever did, mostly because they're doing things that didn't exist when examiners-in-chief were around, which were ex parte reexaminations and interferences. So the opinion relying on Supreme Court precedent for the proposition that if you find a constitutional flaw in a statute, you should try to fix it in as limited a way as possible. And so the court simply rules on constitutional application of the removal provisions of Title V to APJs. Now, in terms of why did we even get here, Arthrex actually raised the issue and that's in contrast to most of the PTAB decisions, and the effect is that sometimes, as we'll see, that means that you don't get to bring it up now. But the Supreme Court has said in other instances, the Freytag case and the Glidden case, that these appointment clause objections are important enough that they can be raised on appeal, and the court here says, well, you couldn't have expected the parties to raise the appeal in front of the PTAB because the PTAB didn't have the authority to decide that they were improperly appointed. So in this particular instance, the panel vacated and remanded that the IPR be heard in front of a panel, a new panel of APJs now, because that unconstitutionality provision had been struck, or unconstitutional provision had been struck. These theoretically would be properly named APJs, but the parties and the government of all petitioned for en banc review, and we'll see in a minute, there's some inkling that even the court is once again split on what they think should be done. This is the government's petition. You can read it at your leisure and go through the next two as well because we don't have time to go through that, but it's there. What's happened since then? So here's a couple of cases where in this bed gear case, the court vacated three of the final written decisions because Arthrex was a precedent, and you'll recall that one three-judge panel cannot overrule another three-judge panel. But both Judges Newman and Dyke expressed what they called severe reservations about giving retroactive effect. This Polaris v. Kingston case, the judges ordered supplemental briefing. In the Unilock case, again, the Federal Circuit vacated the IPR decision and remanded. In the custom medium text case, it was a per curiam opinion that said that custom media had forfeited its challenge because it didn't raise any of these things in its opening brief, and of course that seems a little unfair. Sanofi, similarly, the Federal Circuit denied requests for remand in light of Arthrex, even though Arthrex came down after all the briefs had been filed. But the court still said, no, we're not going to take cognizance of this as a change in the law. This image processing case, the court canceled oral arguments, said this is not worth our time. We're going to vacate and remand back for rehearing. The Duke University case, petition for rehearing that hasn't been decided, and then even in the district courts, there was a request for a 3-month stay, and the district court judge denied that in light of Arthrex because it was unclear what was happening. The site there is Todd Dickinson had a nice blog post in which I got most of the facts here. I tried not to take any of his language. So that actually is where we are. I'll just stop there for a minute before we dive very briefly into Doctrine Equivalence and say it seems what's going to happen here is that depending upon whether the court reviews it en banc, and if it does, it could reverse, or if the Supreme Court ever decides to take a case like this, which it might because it's only tangentially related to patent law, it seems that anybody who thought that this was going to be a get-out-of-jail-free card for IPRs, somehow prevent IPRs being applied to them, don't get your hopes up. I think that IPRs and the whole AIA regime is here to stay. If you think of all the challenges in the Supreme Court, oil states, SAS, all of that, the courts have no stomach for reversing Congress on this. So I think this may be a blip, a road bump, a hiccup, but we're still going to have IPRs. So, Doctrine Equivalence, the reason I bring this up is it's one of the few things where the Supreme Court has actually been very pro-patent. This idea, and it comes from Graver Tank, of course, we all know, that you really can't encompass a tangible thing in words perfectly. And so it would not promote progress, to put it in sort of modern parlance, to have a patent system where unscrupulous copyists were allowed to vitiate the patent right just by being clever. And we've already seen by remarks from Justice Breyer and others that sometimes clever in patent is something that the justices don't like. But they also said there's no benefit to disrupting the public patent protection by permitting avoidance in this way. Although, conversely, designing around is encouraged. But there actually has to be a difference. You have to actually put in the effort. But because nothing is ever perfect, Doctrine of Equivalence is cabined by, most importantly, prosecution history estoppel, this idea that you can't tell the patent office that your claims have a narrow scope and then try to assert them in a broad scope. These other things we probably won't get to, dedication and snarement, et cetera, but they're there more for completeness. The Federal Circuit has had in the 90s taken a position where doctrine of equivalence was something that they were not in favor of. In fact, you could probably make an argument that that the Hilton Davis case and later the Festo case might have raised the Supreme Court's awareness of the degree to which the Federal Circuit was, as a former Solicitor General once said, quietly walking away from Supreme Court decisions it didn't like or didn't think were doctrinally sound. And we'll see that a little bit here. I don't think I've seen a DOE case at the Federal Circuit for 10 years, maybe more. Recently, there's been a bunch, which is why we included it here. This was a case where you had, it's a fairly straightforward case. You had a method of making Neupogen, and it had column chromatography steps that had, you have to wash the column, then you have to elute the column. And these were recited in the claim in independent individual steps. And the way they were written, you would interpret the claim to mean they were sequential, and that would make sense if you think of the physics of it. Well, the accused infringer figured out a way to both wash and elute at the same time, and Amgen tried to assert its claims that was infringing on the doctrine of equivalence because at the end of the day you got purified Neupogen that came out of the column, and so you got the equivalent outcome. And the Federal Circuit said no, they're not. But the dicta that was in the case was here that it applied only in exceptional cases. And that was never the way DOE was understood. In fact, DOE, I've heard say, you should always consider if there's an argument for a doctrine of equivalence infringement. Well, thereafter, the panel came back, and the second part is that dicta now, the opinion reissued with that line drawn through applies only in exceptional cases. And I'll give Jennifer Gordon credit. I think it was her idea. All they had to do was do that, and the opinion would be sound. But I think if you look at this, it's not inconsistent with the antipathy that the Federal Circuit has had to DOE. This UCB versus Watson case was a transdermal patch. There was an issue over which adhesive you would use, and the court said known interchangeability meant that there was a reason to apply doctrine of equivalence here, and that the foreseeability of that wasn't a bar. Interestingly, there was no prosecution history estoppel here because they never amended the claims. And so all the other things, claim limitations, ensnarement, all of that wasn't there. Since people knew that these adhesives are interchangeable, the doctrine of equivalence applied. But it's interesting because there were not insubstantial differences in a lot of the actual physical properties of the two different adhesives, and yet they were still known to be functionally interchangeable. This Inferior case, I think I misspelled it, is an opioid addiction treatment in a film. There was another substitution just to show you how this is really very fact specific. The accused infringer substituted one particular formulation component for another, and the court said no. In this case, there is no infringement because you disclosed that you can make the substitution, but you didn't claim it. And under the Johnson & Johnson case from the late 90s, that was amounted to a dedication to the public. This other Amgen case, it was a combination of salts used to elute something. There was DOE, but it was barred by the prosecution history estoppel and disclaimer because the original claims were very broad and would have encompassed what the infringer did, but in the face of rejections, they were narrowed, and the accused combination wasn't in the claims. And here, and the reason this case is something for your consideration is you have an argument amendment estoppel, where you actually change the scope, and argument estoppel, what was said, and supporting those amendments. This Aspira case, again, accused administration methods, a different salt, okay? Is it equivalent? Yes. The generic salt they used instead of disodium salt was essentially equivalent, but there was no prosecution history estoppel because the amendments that were made were to the drug, not to the salt. And the court, again, in a way that was a little surprising, says you don't demand perfection. I think Don would probably agree that sometimes we feel that we are demanded perfection from patent prosecutors, but the fact that the amendment was peripheral and not direct, or the substitution was peripheral, not directly relevant to the amendment, that Lilly accomplished, and therefore the DOE held. This Ajinomoto case was an ITC case. a way of importing L-tryptophan as an animal feed supplement, and it was made by a couple of different strains of bacteria under the patent. And here is an example of the tangential relationship test. If you remember from Festo, it went through about 13 different iterations between the District Court, the Federal Circuit, and the Supreme Court. One of the things that came out of that was that if the amendment had only a tangential relationship to the claimed invention, it would not bar Doctrine Equivalence infringement under the prosecution history estoppel. And here it was basically the way that you modified the bacteria that made the L-tryptophan. That was, according to the court, a tangential relation. The Pharmatech case is one where it just shows how much trouble you can get into by patent prosecution. It's just a way of detecting glucose, and there are ways that you have a conversion, a chemical conversion that results in a difference in current. Well, as it turned out, that the claim required that you actually do the conversion of the data, and the claimed infringing article didn't do it. And Doctrine Equivalence was barred because the claims were amended to overcome prior art that didn't do the conversion, and you had a great deal of argument about why that made a difference, and no exceptions to the prosecution history get you outside of it, and therefore prosecution history estoppel prevented it. And so what do we get out of this? Well, it all comes back to how a case is prosecuted. Better to avoid having to resort to Doctrine Equivalence in the first place. So, there's no golden rule, there's no magic bullet, but there's lots of ways you can have nested claims. You can do what I call the puntillism approach, because I'm in Chicago and we have great puntillist art in our Art Institute. Just a lot of different claims that cover the field without overlapping, or overlapping independent claims. And dependent claim prolixity just means a lot of them. Sometimes that can get you into trouble, but I think the biggest advice that I can give anybody is first understand what the invention is, understand what the product is, and make sure, and maybe understand how people might try to design around it, because your inventor should be the best, or your client should be the best source of that. And you can probably avoid most instances where you have to resort to Doctrine of Equivalence in any event. But the good news for patentees is that after 10 or so years of not really seeing it very often, and 25 years of the whole idea of the doctrine being bandied about between the Federal Circuit and the Supreme Court, I would say, is much more viable today, under the right circumstances, to protect patent inventions than it's been for a long time. And with that, I think that's my last slide. Back to Patent Docs. And yeah, there we go. And there's us. And I think
we don't have enough time for Q&A like we predicted. But we'll do that offline, probably on the blog. So if you have questions, feel free to submit them to anyone or all three of us, and we'll try to include those along. Thank you for attending today. I hope it was worthwhile. At least for CLE credits, if not for information. And join us on February 18th when Mike's going to give the next MBHB webinar. Everybody have a great day.
Thanks, everybody.